Um, okay, that notes that we're ready to go. Thank you everyone for joining today's webinar looking at environmental litigation. Today we're joined by Aidan Thomson, partner at Weightmans, who is one of the UK's leading environmental law specialists. Aidan works extensively across insurance, utilities, real estate, manufacturing, waste management, and transport, advising on the full spectrum of environmental liability and compliance matters. Today's session will be a look at the environmental litigation landscape as it continues to evolve at pace, with developments in pollution and climate liability both domestically and internationally. This is an opportune moment to consider the emerging trends that will impact London market clients and wider business. So without further ado, I will pass over to Aidan to kick us off. Thank you.
Thanks very much indeed, Ela, and good afternoon to everyone. It's great to be here today to talk or to give this environmental litigation update. Environmental litigation used to be such a niche area, but it's of interest now across a broad range of functions of insurance companies. And it's really important. So just going to look at some broad themes today, and if we could have the next slide, please. I think what I'm going to say today, it's helpful if everyone has in mind the backdrop to environmental litigation in the UK. And what's been happening over the last few years. Certainly after some costs reforms in the late 90s, from that point onwards all the way through to right the way through the noughties, environmental claims became very, very popular. And that's because cost rules were such that it became virtually risk-free for claimants to bring environmental claims. And they brought a lot of them, and claimant law firms developed quite a lot of skills in bringing these actions, in particular group actions. Things got a little bit out of control, and so costs rules changed again in 2013, which made environmental cases much less attractive to bring, much more risky to bring for claimants. But by that stage, claimants had a lot of claimant lawyers had developed quite a lot of knowledge and expertise as to how to bring these cases. And not willing to sort of to give up, they decided. I think what they've been doing is refining the way they go about their business, focusing really on the solid cases, the really solid, sound cases, and also cases that can be scaled up through group litigation or similar to be of a very high value. Once you've got solid cases and high value cases, it makes it much easier for these cases to be externally funded and therefore much more attractive for claimants to bring. So those are the sorts of things they've been doing. And the themes, and we'll be picking up on these themes time and time again over the course of today, the things that they've been, that the claimant lawyers have been looking at in the environmental sphere, where they've been making the most inroads, is first of all international claims. They've been looking at bringing international claims. We'll be talking a lot about those shortly. They've always on the lookout for instigating changes in liability law to give more people the right to bring claims, therefore being able to helping to scale claims up, and also looking for niche circumstances about a particular pollution event that might make a claim easier to bring. And these things that I've just talked about, these are the backdrop. These are the things that we'll be coming back to time and time again over the course of the day. International claims, changes in law, and niche circumstances. Can we have the next slide, please? So let's have a look first at these international claims. Where have we been going, or where have the claimants been going with international claims in recent years. Well, can we have the next slide, please? I think what claimant lawyers have been doing is, in order to find the sorts of cases that they think that they can bring these days, they've been thinking, well, why restrict ourselves to the UK? Why not look for cases of environmental damage worldwide and and try and see if we can bring those claims here in London, where we've got our expertise, we've got our know-how, we've possibly got financing. Why can't we do that? And as a result, the claimant lawyers have been effectively looking abroad for cases of environmental harm and harm to human rights as well. Normally, what would happen, of course, if harm if harm occurs abroad, it should be dealt with in the local courts. But what has happened, and if you have a look at, for example, I mean, this slide was originally taken from the Litigation website. These are all companies that are headquartered or with main offices here in London or in the UK, who have been pursued by who've been pursued here in the courts here on behalf of claimants who live abroad in relation to environmental harm that's occurred abroad. So one of these big multinational companies may have, for example, a subsidiary in Africa or South America that's said to be responsible for an instance of environmental damage. The claimants in those claims are wanting to bring claims, and increasingly those claims are starting to be brought not in the local jurisdiction, but in London, in the UK, where these companies are headquartered. The parent company of the offending subsidiary is headquartered here in the UK. And as you can see already, there are quite a lot of companies that have been pursued in these ways, in this way. Very attractive in many ways, because obviously, if you're looking worldwide, and particularly at developing countries, there are a lot of examples of serious environmental harm being caused, and also the prospect of getting very large numbers of claimants involved in the claim. So, can we have the next slide, please? There have been quite a number of cases over the years as the claimant lawyers have bit by bit sought to enshrine this way of going about things, whereby the problems caused by a subsidiary company of a large multinational based in the UK, those claims can be brought here in the UK. And the kick-off case for that was the Vedanta Resources case on the slide there. That really set the precedent to enable foreign litigants to sue English domiciled companies for environmental damage caused by foreign subsidiaries. That claim was settled a few years ago. Another big claim that's rumbling on now, it's been going on for about 10 years, is a case against Shell here in the UK for alleged spills and environmental damage that have occurred in Nigeria. That's going to be a big case when it comes through. And I think that's going to trial towards the end of this year. That claim is ongoing. Most alarmingly, as a significant development in this line of cases, is a recent case that's been brought against Dyson. Dyson have been pursued not for what its subsidiaries are alleged to have done overseas and damage and harm caused overseas by the subsidiary, but by by people involved in Dyson's supply chain. So not subsidiary companies, supplier companies. Action being brought against Dyson for that. So it's a significant expansion, if you like, of these sorts of cases. The claim was going ahead. The court had decided that the claim against Dyson in the UK, as a result of what had been going on at the hand of its supplier, that claim was allowed to proceed. In fact, just in the last few days, that claim has reached settlement. So, anyway, very interesting development there, and an expansion of this this category of case. Do you want to go on to the next slide, please? Now, I wouldn't be talking about this at the top of the order were it not for a very important case along these lines, where judgment was given in the High Court right at the end of last year. This was a case that arose out of the collapse of a tailings dam in Brazil over 10 years ago. Now, BHP, the mining conglomerate, had 50% joint venture interest in the company that owned that dam, and BHP is based to some extent, the head company is based over here in the UK. So a claim was brought in the UK under Brazilian law on behalf of over 600,000 individuals said to have been involved in this tailings dam collapse. The claimant lawyer in that case, Pogust Goodhead, and in November 2025, the judgment in the High Court on liability in the claimant's favour. So the claimants at the High Court, at least, have won. And a very big decision. Perhaps there will be an appeal, who knows? But if there is no appeal, the case is set to have a hearing on damages. That'll be taking place perhaps this year or early next. And £36 billion are being claimed. So it's whereas all of the other cases that we've had in this line of cases have sort of settled or been discontinued, but by and large settled. This one is the first one that's really gone all the way, and as you can see, very significant judgment against the defendants there. Can we have the next slide, please? So just some concluding thoughts on these international claims. Certainly this BHP case marks a shift from just theoretical exposures of UK headquartered corporates to real large-scale liability. Those are awesome numbers, and huge numbers of claimants as well. And also, and it really is important for people to understand what claims against UK insureds might arise from the activities of overseas group companies or even overseas suppliers going forward. And I suppose it's not just a question of who you insure, but people who insurers invest in, or companies that insurers invest in, could be hit by these sorts of claims. And indeed, I mean, others involved on the periphery, like insurers themselves, who could be said to have enabled certain companies to operate in some of these overseas jurisdictions. Who knows? Maybe one day claimant lawyers will have a pop at insurers based here in the UK for similar sorts of actions. So anyway, that's international claims. A big moving thing at the moment. We'll certainly big BHP decision. Keep a lookout for that Shell decision as well that I mentioned earlier over the course of the next few months. Can we have the next slide, please? Thank you. So that's yes, international claims. So you can see that claimant lawyers are making some very good progress on those international claims. It provides them with very significant numbers of claimants, very large amounts of damages at issue, precisely the sorts of group actions that I think they'd be very keen to pursue. We'll move on to water pollution now. Just say a few things about water pollution, because that water pollution, of course, is another big area at the moment, particularly the UK. Can I have the next slide, please? I've just going through these slides here, having just binged watched the Channel 4 drama documentary, A Dirty Business, over the course of the weekend, which is all about the water industry and its trials and tribulations over the course of the last few years. And that does provide, to the extent that drama documentaries can, some very useful background into what's going on in the water industry at the moment. There's been, as everyone knows, a huge amount of scrutiny of sewage pollution over the last few months and years. It's fair to say that a very large number of people are pretty outraged by what has happened. And obviously, when you have large numbers of people who feel sufficiently motivated, that is a very good backdrop for legal actions, in particular group claims. And law firms, or claimant law firms, have been very active in this area. As you know, the facts about water and sewage pollution have gradually become established in recent years. Now, the first thing that they decide, and obviously, and what I think on the litigation side of things, claimant law firms are wanting large numbers of claimants if they possibly can. And yes, there seems to be a huge amount of public interest here. They're wanting to scale up, perhaps, get large amounts of damages at issue, and the hope that makes funding easier, makes the claims easier to get off the ground. So yes, very fertile territory here for large pieces of litigation. The first thing that happened was just over 2 years ago. Litigation Co. Brought collective proceedings against the water companies under the Competition Act. Very interesting. They weren't. The claim was being brought not for pollution as such, damages for pollution, but on the basis that water companies had not been sort of straight with their regulator Ofwat about their performance, and as a result had been able to charge water customers more for their water than would otherwise have been the case. And the gist of this action is that Litigation Co., on behalf of water customers, wanted some of that money back. It was a claim for about £1 billion, so quite a large claim. That claim, which was under sort of competition legislation, sort of hit the buffers initially, but it is being it wasn't allowed to proceed originally under the competition regime. But that's been appealed, and I think the appeal is happening very soon. So that case, which is has some very large numbers attached to it against all of the main UK water companies, is ongoing, and we'll hear more about that in due course. But the thing that gave claimants and claimant lawyers a real leg up in this area was a decision in July 2024, Manchester Ship Canal against United Utilities. I guess Manchester Ship Canal were unhappy that United Utilities were discharging sewage into the Manchester Ship Canal during rainy periods, and brought this case, which went on for a long time. I think most commentators thought that for reasons linked to the statutory regime around the water industry, it wasn't possible for Manchester Ship Canal to bring a tort claim for damages against United Utilities. A decision many years ago called the Marchik decision indicated that water companies couldn't easily be made liable in tort for pollution in this way. And I think a lot of commentators, myself included, were very surprised to find that actually Manchester Ship Canal were told that yes, they were allowed to sue in tort. There was no sort of statutory or regulatory bar to these actions taking place, and that if United Utilities had polluted the canal, a claim in tort could be advanced. It wasn't saying that United Utilities had to pay out, but that in principle a claim could be brought. Well, of course, that has greatly enlivened the claimant lawyers, who now know that there is no sort of regulatory bar to water and sewage companies being sued in tort for sewage pollution. So immediately, straight out of the blocks, there are three cases that I know of that are sort of ongoing at various stages. And bear in mind that there are many, many, many locations around the country where these sorts of cases could be replicated, depending on how the case law goes. So we've got a big claim going on in Exmouth, down in Devon, which seems to now include not just Exmouth, but quite a number of other locations along the coast in that area. We've got a new case on the River Wye, which I'll talk about in a second, and also a case, Windermere in the Lake District, which is also said to have been suffering from sewage pollution. Go to the next slide, please. Now, this River Wye pollution claim is probably the most advanced of all of those. 4,000 claimants for involved with a variety of connections to the River Wye, saying that the pollution has affected them in various ways. It's a claim in tort and under for breach of statutory duty. The claims against Welsh Water, principally, but there are also two food companies who are said to have caused polluted runoff into the River Wye. And it's said to be the largest claim brought in the UK for environmental pollution, for UK environmental pollution, based on the number of claimants, etc. So I think that's right. 4,000 claimants. I mean, obviously, it pales into insignificance in comparison to the BHP case that I was talking about earlier. But that's damage and harm that's taken place in another country. This is the largest claim, I think, where the damage is said to have occurred here. Grab the next slide, please. So what are the points to consider here? Well, I'd love to know how these claimants are managing their costs risk. It's not entirely clear how they are funding the claim. I'm sure that will become that will become clearer. I mean, obviously, good funding is a prerequisite for being able to see this case through effectively. Interestingly, I do wonder also how sound the claims are. Um, I'm not sure how choosy the claimant lawyers have been about, putting forward only the strongest cases. That's quite interesting. I think that they are hoping for some sort of change in environmental liability law in order for some of the claimants to actually make their claims good. In particular, those who don't own property actually own property in the local area. Are the claims of high value individually or collectively? Well, there are said to be 4,000 claimants, and there are some niche circumstances as well. I think they're taking advantage of some sort of planning moratorium that resulted from the pollution that caused people in businesses to incur costs. Now, obviously, the claim against the water company, Welsh Water, is going to be very different to the claim against the food companies. So we'll wait and see what happens there. But claimant lawyers will have considered the position here very, very carefully indeed. They're wanting to use this opportunity, I think, to establish, exactly how water pollution, well, sewage pollution claims in the future can be run, and whether this is a model that can be replicated over lots and lots of different sites that have been subject to sewage pollution. And also there'll be an awful lot of learning that they will get from these cases that they'll put to good use in relation to other kinds of water pollution going forward. I'm thinking in particular there about PFAS pollution claims. So there's an awful lot riding on this. The River Wye case is just the sort of thin end of the wedge. It could lead to so much more. Go to the next slide, please. Okay. That's water pollution behind us. Another big strand of litigation that we've got here is climate liability litigation. And if we have the next slide, please. You'll see that broadly, we've been talking about this climate liability litigation for years and years. I first gave a talk to the Geneva Association in 2010, talking about climate liability litigation. It has been an issue that's been going on for a very long time, but it's starting to get traction now. What are we talking about when we talk about climate liability litigation? Well, the first kind of claim is where individuals, shareholders, and company stakeholders use the corporate reporting that companies are required to do these years to attack the company's direction, to attack the directors for not properly taking into account climate-related issues. A couple of big cases that have hit the headlines recently. Obviously, there's Shell being pursued by Client Earth. That case didn't go anywhere, but I think we expect more of the same, certainly in the UK. And also a case at the moment against the Canada Pension Fund and their climate risk practices in how they run their fund. Most of these cases so far have been brought just by pressure groups who are wanting to highlight the way companies are going about their climate-related business. But in due course, where people have lost money as a result of the companies they're invested in, expect those actions to be for significant amounts of damages. But today I want to talk more about the other kind of climate liability litigation, the injury and damage litigation that has started to materialize. These are cases where basically people who have suffered from climate-related injury or loss, bring a claim against a company that is said to have been responsible for the greenhouse gases that have brought that particular weather event about. Obviously, the potential for damages here across entire communities affected by weather events is absolutely huge. The thing standing in claimant's way, though, in the claimant's way, is evidential difficulties, and proving that one company's emissions has had a material effect on the weather, on producing the weather event that is said to be the cause of the damage. But get this right, and if the evidence starts to stack up, then claimants or claimant lawyers in the UK will be very, very interested. They'll be able to take damage that has occurred right around the world and potentially bring claims against companies headquartered here in the UK that are said to have been responsible for at least part of that adverse weather event. We have the next slide, please. It's a huge evidential task to try and make these claims stick, but the claimants are chipping away, not just and they're chipping away internationally. In one case in Germany last year, called the Peruvian farmer case. Peruvian farmer bringing a claim against the German utility RWE in Germany for the melting of a glacier and the eventual flood risk that will cause in Peru, or to a village or a town in Peru. RWE are responsible, or said to be responsible, for a very large chunk of carbon dioxide in the atmosphere, and that was said to be linked to the melting of this glacier. That case didn't go very far. It got knocked out last year, mainly because the damage in Germany, the damage that was alleged was too far away. It wasn't imminent enough for the court to be able to take it seriously. But they said if someone wanted to come along with more imminent damage, we would take that very seriously. That would be a different matter. We'd look at that case. So, surprise, surprise, within a few months, another case was launched by a group of farmers in Pakistan who had been affected by some very, very bad weather over a long period, I think about 2 or 3 years ago. The Pakistan farmers case has started in Germany, again against RWE and I believe Heidelberg Cement, and those we'll see what happens. We'll see what the German courts make of the damage that these farmers have sustained, and whether indeed it can be linked to carbon dioxide that these German companies are said to have put in the atmosphere. There's been a decision of the International Court of Justice, and just an advisory opinion that basically says that nations are accountable in principle to people who suffer climate harm. That was from last year. Just an advisory opinion, but it all sort of adds to the backdrop of these sorts of cases. And I think most interestingly, and this sort of ties in to what we've been saying right the way through this discussion, is a case that's just been launched against Shell again, unfortunately, in the UK by a group of people who have suffered harm in the Philippines as a result of Typhoon Odette. They say that Typhoon Odette was much more serious than it would otherwise have been because of the carbon dioxide for which Shell was responsible. Um, we see here claimant lawyers dipping their toe in the water, trying to bring the claim um, in the UK for this damage that has happened elsewhere. So bringing one of these big international claims in the UK for climate damage. Obviously, we'll be very interested to see how that one goes. If these claimants make any progress at all against Shell, that will serve to encourage similar sorts of claims being brought in the UK against UK parented companies relating to damage elsewhere. So very, 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 very interesting development that, and we really need to keep an eye on that Typhoon Odette case. Of the next slide, please. So yes, that's the end of climate litigation. Some very interesting developments there. Very big cases lend themselves to enormous group actions with very large damages attached to them if they can ever get the evidential questions right or answered satisfactorily. Okay, so now finally we're going to have a look at PFAS regulation and liability. I wasn't really going to touch on this, but I'm asked to do so because there's been quite an interesting UK development. So let's just quickly rattle through PFAS and cover this development. Go to the next slide, please. Now, I think everybody knows or will be familiar with what's been happening on PFAS over the last couple of years. In the UK, we've got some claims or potential claims bubbling in two locations, Bentham and Thornton Cleveley in Yorkshire and Lancashire, respectively. Those are sort of stalking horses. There's plenty more where those came from, depending on how these sorts of cases make progress in the early stages. Who knows what sort of claims will emerge from that? Water pollution claims, possibly personal injury claims. We'll see. There's very active litigation in the US, of course. Water pollution claims have been settled by DuPont and 3M, water pollution claims brought by water suppliers or municipal water suppliers. Big settlements there. And plenty of liability litigation right across the EU. Can we have the next slide, please? Now, I think that these claims are certainly boosted by the regulation that is in place in some of these countries. In the EU and the US, it's very clear that there is quite a lot of PFAS regulation now, in particular on drinking water and the maximum amounts of PFAS that can be in drinking water. But other kinds of regulation too. And I think the fact that there are these limits on PFAS in drinking water, very strict limits in the EU and the US, that is why the drinking water pollution claims in those countries, very high value, have been able to get off the ground. It's very simple for a water company to say, I'm very sorry, but you've polluted my water source. It's the water that I was putting into my water supply network now has too much of this PFAS in it. I'm going to have to dig lots of new boreholes somewhere else, and you need to pay for it. That's a very sort of clean cut type of case to bring, where you have a very, very clear limit on the amount of PFAS that you can have in drinking water. Here in the UK, though, we've been very much slower to introduce these PFAS regulatory limits and thresholds. And that, I think, is one of the main reasons why we've seen less PFAS litigation here than in some of these other jurisdictions. Go to the next slide, please. But just last month, just literally a few days ago, DEFRA in the UK issued its PFAS plan. It said, yep, we've got to really get on top of this now, everyone. And it arranged for a whole load of things to be done, was put in train a whole load of things to be done that will have an impact, I think, on the ease with which PFAS claims can be brought in the UK. First of all, they're thinking about introducing restrictions on PFAS in new products. Um, that's one thing. And about reducing emissions from industrial processes. So changing environmental permits to really ratchet down on any PFAS emissions. There's going to be a review of evidence to support human health risk assessment. One of the main problems with bringing personal injury cases in this country as a result of PFAS poisoning is that people don't really know. People think that it's, causes cancer. In fact, it very likely does. Um, but but the precise amounts that are required and the precise effect that it has is not understood. That is going to be investigated far more, and and as that happens, it will perhaps become easier to bring personal injury cases. In the UK, they're thinking of introducing a statutory limit for PFAS in public water supply regulations to make us like other jurisdictions. And that's led, as I've said, to some very large claims by municipal water suppliers. Some thresholds for PFAS in the water environment and updated guidance for local authorities' regulatory responsibilities. The people like the Environment Agency and local authorities would be requiring the cleanup of PFAS contaminated land far more, far more than they have been to date. If they had clearer guidance as to what is contaminated and what's not, that's going to be rectified quite soon. Can we have the next slide, please? So just looking at what's going to happen with PFAS in the UK going forward now. First of all, I think we're going to start getting those water pollution claims that have been a feature of other jurisdictions. They'll be the first things to arrive, and regulatory cleanup actions likely in due course as well. Those things will cause a whole load of arguments between companies who in the course of their corporate activities have been trying to allocate contamination liabilities in sale and purchase agreements. So those liabilities will start triggering a whole lot of contractual liability transfer spats between corporates, and I think we can expect to see quite a lot of those. This is all very fertile ground for group actions. Large numbers of people, suffering from, you've got large numbers of people who've said to have been ingesting PFAS, very likely get large group actions resulting, and especially to the extent that water pollution will be an issue. Of course, the claimant law firms will have all of the knowledge that they'll have been gathering as a result of their exercises in relation to sewage pollution, and they'll be able to transfer all of that over. So it's very fertile ground for group actions. I would imagine that claimant lawyers will be very keen to pursue changes in liability law, very keen to try and do that, as they did with asbestos claims a few years ago. Remember, everyone says that PFAS is the new asbestos, and it's very common within the asbestos scenario for claimant lawyers to try and change liability law in relation to things like plural plaques. That happened with asbestos. Similar sorts of things may well happen with PFAS. We'll have to see, and that will give rise, obviously, to coverage questions as well. Obviously, PFAS contamination has been happening over many years. The chances of the triggering of much older liability policies, depending on how these claims pan out. I think that brings me to the end of what I was wanting to sort of say formally. I think we'll probably have some time for questions, but there's just some background reading for everybody. I've put a few blogs that we've prepared there on the slide, and very welcome just to. I'm sure we've got a copy of these slides after the session, so please take a look at some of those blogs, which talk largely about what I've been saying over the last 40 minutes or so. And that brings us to an end, Ella. Ella, should we have some questions now?
Yeah, if anyone has any questions that they want to put forward to Aidan, please feel free to pop them in the Q&A chat. I have one to kick us off though.
Right.
You were talking a bit at the end about PFAS in particular, which is quite a common topic of discussion for our
Mm.
general liability underwriters within one of our committees. And you mentioned the new framework that DEFRA will be introducing, looking specifically at putting some statutory limits on PFAS. Do you foresee that having a significant impact in particular for insurers? Because I know there are often discussions around whether, causation for bodily injury for PFAS and other pollutants, chemicals, make it quite difficult to actually have successful claims in those sorts of situations. But do you foresee having those statutory limits put in place, making that a little bit easier to pursue?
Absolutely, I do. I think it's going to make a big difference. I mean, at the moment, in relation to regulatory actions, and the regulators, like the local authorities, just simply they get very nervous when they don't have a particular number that they've been told is the maximum threshold, right? If they haven't got that number set out in guidance, they will have to hum and ha about exactly what number they are going to use, and that will be open to challenge, and the whole thing becomes far more difficult for them. So as a result, they think we're not going to do that. With the same in litigation. If claimants were to bring claims for personal injury, I mean it's very difficult at the moment without some much clearer numbers and thresholds to bring those sorts of claims. But once you start getting those numbers, for example, if a water company now were to want to bring an action because its water supplies have become contaminated with PFAS, they would be asked. They would have to demonstrate why those levels of PFAS in their water were said to be unacceptable, and there's no regulation at the moment that they can rely on. No threshold numbers, so they'd have to present the case themselves, and that's only going to be challenged. It'll be very difficult. But if there is a law that says in water supply law that water cannot be lawfully supplied to the general public where the PFAS in it is above X concentration, it's very much easier for the for a water company to make that to bring an action. They can basically say, look, my water supply has been contaminated to the extent that I cannot lawfully sell it. Doesn't matter whether it's harmful or not. It exceeds the limit that's been set out by law. It makes it a much cleaner case for the water suppliers to bring. And indeed, that was what happened many years ago in relation to a different kind of contamination, a famous case called Cambridge Water and Eastern Counties Leather, and that was Cambridge Water complaining about some pollution it was bromide pollution that was being complained of then by Cambridge Water, and all they had to say was I'm very sorry, but we're not allowed to put water into our taps that contains bromide above a certain level. And I'm afraid you've caused our water to be above that level. So we're bringing a claim. I mean, the claim actually failed for other reasons, but it certainly was able to get off the ground very, very easily. So yes, I think that once this PFAS plan has been enacted, and in particular, once local authorities and drinking water inspectorates have got these numbers, and water companies have got these threshold numbers that they can rely on, it will make a big difference. Sorry, that's quite a
No, it's very
long
helpful.
explanation, but I think it's a very, very important point that you've come up with. Now, some more questions have come up.
Yes. The first one was, can jurisdiction clauses prevent from forum shopping on some of the cases you mentioned initially, where there is a parent company and then international subsidiaries involved?
Well, I'm not sure that I understand that question. I mean, it's jurisdiction clauses. I mean, these are claimants who are bringing claims in tort. They will not have signed up to any jurisdiction clause. They won't be required claimants to bring their claim in any particular country because they have no contract with the person who's the defendant in the case. I'm not sure that perhaps I don't fully understand the question, but no, there's the claimants can bring the claim wherever they think there's a court that will hear it, and they can get finance. They can be financed for it, and it won't really matter what what jurisdiction clauses are in any other contracts.
Okay. And then the next question we had, which was again relating to PFAS, was do you think the PFAS plan for the UK will be fully pursued as planned, or do you foresee some of the elements in the plan being swept under the rug in efforts to prevent a surge in water pollution related claims? And then also the plan is available on the government website, just to answer that second part.
Yes, the plan is available on the government website, and it's quite readable. It's quite short, and that sort of feeds into the first part of that question, which is what is going to is it all going to be pursued? I mean, yes, I mean, it's quite short, so there are bits of it that are going to need to be fleshed out. And when that happens, you find that it all gets diverted and things go slower than you'd planned. But I think that inevitably there'll be some things that do have to happen as a result of this PFAS plan. I think we know we're falling behind a bit. I think that some things are going to happen, and I think the things that really are likely. I think that guidance for regulators over contaminated land and drinking water limits are things that are going to be considered, and considered reasonably soon. Whether or not, when those limits come out, whether there are loopholes and gaps and that sort of thing, I don't really know. But I think that there is enough that definitely will happen as a result of this PFAS plan to keep everybody interested. So yes, some things may fall by the wayside, but there'll be enough to make a difference, or potentially make a difference to the liability landscape. Ooh, another question.
Yes, the next one we had was, do you see within insurance or reinsurance companies outright exclusions of PFAS within recent years? And continuing that the law may circumvent, for lack of a better word, paying claims to set precedent, and how could that range in the US, EU, UK, do you think?
Um, yes, I mean, I think that it has we've seen it more and more onto you. PFAS exclusions within policies, but of course those are relatively recent. Um, And of course, the discussion at the moment is about what about those policies from way back that may be triggered. And yes, I mean obviously there is a chance that that um, people will start settling those claims. Just reading the second part of the question. Foreseeable loopholes. Um, but I don't think. I mean, I think that PFAS exclusions at the moment are very they're quite basic, sort of one or two line affairs. Um, and I think people do need to keep a very close eye on those PFAS um, exclusions as we start seeing the litigation coming through, because I think that they may well need to be refined. There's the possibility of regulatory claims, personal injury claims, cleanup claims, great many different kinds of claim, and I think that you need to be very, very careful with those exclusions to make sure that they cover exactly what they need to cover, and at the same time, you know, allow legitimate claims to be paid. Um,
We have
okay.
one final
Yep.
question.
Yep.
Um, just on with an eye on the time, but we were asked, would pollution exclusions bite to provide a defense for insurers in relation to a substantial number of these claims? Are there any foreseeable loopholes which might see insurers being required to pay despite the insertion of pollution clauses?
Well, I mean, there are. I think that a lot of pollution exclusions. I mean, PFAS is definitely a pollutant, um, but especially in relation to the environment, though, well, pollution exclusions do sort of allow or don't exclude pollution that results from sudden and accidental incidents or events. Um, And a lot of it would be an interesting question to see the extent to which PFAS could be said to have resulted from some sort of sudden event in the past. I mean, a lot of PFAS will of course be gradual, but won't always. You've got to look at the facts of every single polluting circumstance before you can sort of apply the apply the exclusion. And I would say that not every these pollution exclusions might be useful to a large extent to exclude PFAS related claims, but not always the case. It depends on how the pollution actually arose in the first place. I hope that's answered everyone's questions. It's a great shame actually, because you can't have a sort of a dialogue when you only see
Sure.
the question on the screen there. I hope that answers or tries to answer some of the questions that have been raised.
No, that was very helpful, Aidan. Thank you very much. If people do have any follow-up questions, would they be able to get in touch with you to ask about those or?
Absolutely, they're welcome to do so. Yeah,
Perfect. Okay. Well, in that case, I will close the session there for today, but we will follow up with contact details in case anyone does want to get in touch and follow up. Yeah, but we'll end it there for today. Thank you very much.
thank you. Thanks everyone.